Okay, let's talk about borders. The power a government have to decide who can and cannot enter a country feels pretty fundamental, right? It's uh, core to the idea of sovereignty.
Hmm.
But how exactly is that power put into practice? And maybe even more importantly, when it is used, how is it challenged?
It's a profound question because it touches on law, history, national identity, and, well, the lives of actual people. It's far more than just administrative policy.
Absolutely. And that's what we're digging into today. We're taking a deep dive into the stack of sources you've shared with us regarding the Trump-era travel bans.
Yeah, there's quite a bit here.
We have a lot to work with: actual Supreme Court documents, legal analyses, breaking down the arguments, reports detailing the very real human impact.
Explorations of the historical backdrop for this power.
Right, and even pieces looking at how these issues might reappear in potential future policies.
It's a comprehensive set of materials that lets us really get into the different facets of this incredibly complex issue.
Our mission is simple: to unpack these documents together, pull out the most important insights, and help you see the layers here from the policy's stated goals and the fierce legal battles it triggered.
All the way through to the personal stories and those historical precedents.
Yeah, let's figure out what's really going on here, beyond the headlines.
Sounds of a crucial exploration. Let's start right at the beginning with the policy itself.
Right. You can't really talk about this without acknowledging the political context. We have candidate Trump's campaign promise, which was quite striking, calling for a total and complete shutdown of Muslims entering the United States.
And that statement, which, remained on his campaign website for some time, became a really significant piece of evidence later on.
Right.
When legal challenges were brought, arguing about the administration's intent behind the policy.
Following the campaign, we saw the executive actions. Initially, Executive Order 13769, quickly replaced by EO 13780, and then ultimately Proclamation 9645.
Right.
These were the directives that implemented the entry restrictions.
And Proclamation 9645 is the one that really matters from a legal standpoint, because it's the version that went all the way to the Supreme Court.
Okay.
The stated goals of this proclamation were twofold. First, to prevent the entry of foreign nationals the U.S. government felt it didn't have enough information about. And second, to encourage foreign governments to improve their systems for managing identity information and sharing it with the U.S.
It wasn't a blanket ban on everyone, or even every country, though. The restrictions were actually tailored based on what the administration described as the distinct circumstances in each specific country.
Yeah.
Initially, it targeted 8 countries. Places like Iran, Libya, Somalia, Syria, and Yemen were on that list.
Crucially, the proclamation did include exemptions, notably for lawful permanent residents already here,
Okay.
and provisions for individuals to apply for waivers on a case-by-case basis, though, as the sources detail, the implementation of those waivers became a real point of contention.
Right, we'll get into that. And there was even a mechanism for review built into the policy itself. It required the Department of Homeland Security to reassess these restrictions regularly every 180 days.
Which actually did lead to a change.
Right, did, yeah. Interestingly, this process actually led to the lifting of restrictions on nationals from Chad after their government apparently improved its information sharing practices.
So, while the shorthand in public discussion was often just the travel ban, the official policy had a specific structure. Targeted countries based on perceived security or information sharing risks,
Exemptions.
waivers, and a review process.
Yeah.
That framework was central to how the legal system, grappled with it.
Which leads us to the fundamental legal and historical question. Where does a president even get the authority to do this?
This is where the Supreme Court sources take us deep into history. There's a long-standing principle that the power to admit or exclude foreign nationals is a fundamental sovereign attribute. It's seen as belonging primarily to the government's political branches, Congress and the executive, and is often described as being largely immune from judicial control.
So the courts tend to be very deferential to the president or Congress on these kinds of decisions.
Exactly. The court has cited cases going back decades, even over a century, like Fialo v. Bell and Harises v. Shaughnessy. These decisions often link immigration policy closely to areas like foreign relations or even war powers,
Right.
reinforcing the idea that the executive has wide latitude here.
And the sources show this isn't just theoretical power. Presidents have used it, specifically under a particular law, Section 1182 of the Immigration and Nationality Act.
Right, 1182.
This law allows the president to suspend the entry of any aliens or class of aliens deemed detrimental to U.S. interests.
And the Supreme Court sources point out that presidents have used this power not just against individuals for specific harmful acts, but sometimes quite broadly.
Broadly how?
Well, they've suspended entry for entire classes of people, often nationals of a particular country, sometimes to put pressure on foreign governments whose conduct conflicts with U.S. foreign policy.
That's a key point. It wasn't always about an individual person being a security threat.
Exactly.
The court mentions examples like President Obama suspending entry for certain Russian nationals in response to actions in Ukraine, President Clinton doing the same for Sudanese officials.
Or President Reagan suspending entry for almost all Cuban nationals as pressure on Castro's government.
Right, so some of these were broad nationality-based actions under this same authority.
Right. The government's argument in defending the travel ban leaned heavily on this history and the broad wording of Section 1182 Esite, saying the president was acting within this well-established authority.
But here's where we hit a major point of tension in the law, because the Immigration and Nationality Act also contains a different provision.
It does. The INA was significantly reformed in 1965, and it includes a non-discrimination clause stating, no person shall receive any preference or priority or be discriminated against in the issuance of an immigrant visa because of his race, sex, nationality, place of birth, or place of residence.
So on one hand, you have this broad presidential power, historically used potentially on a nationality basis for national security or foreign policy reasons. On the other, you have a more recent law saying you can't discriminate in issuing immigrant visas based on nationality.
And that became a central legal debate. Did the president's broad authority under 1182 for national security reasons override the 1965 non-discrimination clause in this specific case?
Or did the 1965 law mean this nationality-based ban was illegal, at least for immigrant visas?
Exactly. Some legal experts argued it clearly violated the 1965 law, while others argue the president's national security power took precedence, or that the 1965 clause doesn't apply to barring entry entirely or even non-immigrant visas. It was a real split.
That fundamental tension set the stage for the legal battles that erupted almost immediately after the first executive order was issued.
Absolutely. Lawsuits were filed all over the country, challenging the orders on various grounds. People argued it violated the INA, that it violated the Constitution's Establishment Clause by targeting Muslims.
Right, the religion aspect.
And other constitutional issues like due process.
One of the earliest and most high-profile rulings came from a federal judge in Washington state, which was then upheld by the Ninth Circuit Court of Appeals regarding an earlier version of the ban.
Yes, the Ninth Circuit denied the government's request to put a temporary restraining order on hold. And they were pretty sharp in their ruling.
How so?
They said Washington state had the right to sue because the ban harmed its residents and universities. They rejected the idea that the president had completely unfettered power here, stating the courts could review it.
Okay.
They also expressed skepticism about the administration's argument that the ban was immediately necessary for security and raised concerns about due process for people affected.
And that ruling, of course, famously led to President Trump's tweet, "See you in court," in all caps.
Right.
It really underscored how quickly this went from policy to intense legal conflict.
Other district courts also issued injunctions. For example, Judge Twang in Maryland blocked parts of the revised executive order.
Okay, the second version.
Yeah. Specifically, finding a strong likelihood that it violated the Establishment Clause due to evidence of anti-Muslim intent, and also that it likely violated the 1965 non-discrimination provision, specifically as it applied to immigrant visas.
So this brings us back to that core argument. Was this policy genuinely about national security, or was it primarily motivated by a desire to discriminate against Muslims, which would be unconstitutional under the Establishment Clause?
That question of animus discriminatory intent was central to the challenges. The sources highlight how challengers and later the dissenting Supreme Court justices pointed repeatedly to President Trump's campaign statements.
Like the call for a total and complete shutdown.
Exactly. And his repeated use of the phrase travel ban, and statements from White House officials saying the revised policy achieved the same basic policy outcome as the initial one and fulfilled campaign promises.
The argument was, look at the president's words, look at the context. The stated security reasons are just a cover, basically, for religious discrimination.
Yes, that's the core of the animus argument. However, The Georgetown law source notes that courts face a real challenge when interpreting presidential statements, especially concerning foreign affairs or national security.
Why is that?
Well, statements might have multiple audiences, they might be used for political messaging, and have complex motives. It's difficult for a court to definitively say this statement proves the only motivation for the policy was discriminatory.
And that difficulty played a big role when the case reached the highest court.
It certainly did. Which brings us to the major decision, the Supreme Court's ruling in Trump v. Hawaii.
What was the final outcome?
In a 5-4 decision, the Supreme Court ultimately upheld Proclamation 9645.
Okay, they upheld it. And what was the majority's reasoning?
The majority opinion, led by Chief Justice Roberts, emphasized that significant deference is owed to the executive branch in matters of national security and immigration.
Right, that deference principle again.
Exactly. They viewed the proclamation as facially legitimate, meaning on its face it stated a valid national security purpose and within the broad authority granted to the president under Section 1182 Aleph.
So they relied on that history we discussed.
Very much so, noting that presidents have historically used this power, including actions that broadly restricted entry based on nationality.
Okay, but how did they deal with that powerful argument about animus, about the president's statement suggesting anti-Muslim intent? That seems like a big hurdle.
This is a critical point in the decision and, frankly, a source of significant debate. The majority acknowledged the statements but ultimately concluded they were not enough to show the proclamation itself was primarily motivated by religious animus.
How did they square that?
They focused on the stated national security goals and the specific structure of the proclamation, the review process, the country-specific findings, the waivers finding it had a legitimate purpose related to information sharing and security. They essentially separated the president's rhetoric from the policy document itself.
I remember the Yale Law Journal source had a really sharp critique about how the majority addressed the animus point, connecting it to Korematsu.
Yes, it's a fascinating and troubling comparison the Yale piece draws. The majority opinion included a phrase stating, in reference to the infamous 1944 Korematsu decision that upheld Japanese-American internment during WWII, that Korematsu was not excluded from the military area because of hostility to him or his race.
Which is a controversial statement about Korematsu.
Highly controversial. And the Yale analysis argues that this statement, and the majority's approach in Hawaii more broadly, is problematic. The insight here is that the Hawaiian majority, much like the Korematsu court, accepted the government's stated justification national security necessity at face value.
Showing great deference.
Right. Great deference to the executive.
Yeah.
While arguably sweeping aside compelling evidence of potential discriminatory intent.
So the critique is that in both cases, the court accepted a remotely plausible claim from the government based on national security and presidential authority without really digging into the ugly real motivations that challengers argued were actually driving the policy.
Exactly. The Yale article highlights how judicial deference, while sometimes necessary in national security, can, in certain contexts, risk allowing potentially discriminatory policies to stand if courts are unwilling to look past the stated rationale to examine the evidence of underlying intent.
Wow.
It's a powerful echo back to a decision widely regarded as a stain on the court's history.
It really underscores the concern that when courts defer too much to executive claims of necessity, especially during perceived crises or in national security matters, fundamental rights can be jeopardized.
No question.
The dissenting justices clearly saw it differently.
They did. Justice Sotomayor, joined by Justice Ginsburg, wrote a powerful dissent, arguing that the context was inseparable from the policy. She felt that any reasonable observer, looking at the president's history of statements and the timing of the policy, would conclude it was rooted in anti-Muslim animus.
She just wasn't buying the national security rationale.
Pretty much. She argued that the policy failed even the lowest level of constitutional review, rational basis review, because the evidence of discrimination was so strong. She felt the majority was deliberately ignoring the obvious signs of discriminatory intent, that the justification was pretextual.
And there was another dissent too, right? From Justice Breyer.
Yes. Justice Breyer, joined by Justice Kagan, wrote another dissent focusing less on the underlying intent and more on the practical implementation of the policy.
Implementation? How so?
He specifically questioned whether the waiver process was actually working as intended. He cited the example of a specific family who faced immense difficulty getting a waiver despite seemingly meeting the criteria.
So he looked at the reality on the ground.
Exactly.
Mm.
He argued that the way the waivers were being processed, or perhaps not being processed effectively, suggested that the policy's real-world effect might be different than its stated purpose, and that more fact-finding was needed to understand if these waivers were truly available.
So even though the Supreme Court upheld the proclamation, the debate didn't end there. The dissents pointed to fundamental disagreements about how courts should weigh presidential rhetoric and implementation realities against stated policy goals.
Precisely. And the impact of these policies stretched far beyond the courtroom arguments, drawing other significant critiques.
One of the most powerful things in the sources is hearing about the human cost. The ACLU source really brings this to life, with stories of people whose lives were just derailed by these policies.
Yes, these are stories that show the real consequences of the legal and policy decisions. We hear about people like Mautaz Abdelazim, an accountant who had won the diversity visa lottery,
Right, the DV lottery.
a program designed to bring people from countries with lower rates of immigration, only to have his opportunity blocked by the policy, leaving his future uncertain despite his qualifications.
Just stuck in limbo.
Completely.
Yeah.
And Ekaterina Karslidi, a journalist from Russia who also won the lottery, but found her immigration process became effectively impossible as consulates shut down, first due to the pandemic and then the invasion of Ukraine.
So multiple factors compounding the problem.
Exactly. She could come here and faced great difficulty returning home. Or Ahmad, a diversity visa winner from Afghanistan. His chance was lost due to the ban, leaving him fearing the Taliban's rule and deeply worried about his children, particularly his daughters whose education is now denied.
These aren't just abstract cases, they are individuals whose hopes and lives were profoundly impacted. The ACLU memo describes these as broken promises, highlighting how policies like the travel ban undercut programs that offer legitimate pathways to immigration and change individual destinies.
And separate from the human cost, there were also critiques from people focused specifically on national security, arguing that the bans weren't just unnecessary, but were actually harmful to America's safety.
Harmful? How so? That seems counterintuitive to the stated goal.
Well, a source featuring perspectives from former national security officials argues that the bans damaged America's reputation and strained relationships with foreign partners.
Ah, okay.
The core insight here is that cooperation and intelligence sharing with other countries are absolutely vital for actual national security. By alienating potential partners with broad restrictions, the argument goes, the U.S. made itself less safe, not more.
So the argument is that intelligence and information are our best defense, and the ban hindered our ability to get that information.
That's the perspective they present.
Right.
They also argue that travel restrictions weren't truly necessary because U.S. vetting and screening processes had already been significantly improved since 9/11,
Right.
making the blanket bans redundant or, overkill from a security standpoint.
And instead of bans, they suggest the U.S. could have used the insights gained from the review process, identifying countries with information sharing deficiencies.
Right, the process built into the
To
proclamation.
work collaboratively with those countries to raise global security standards.
It's an argument for a different approach to achieving the same stated goal of enhancing security, one based on partnership and capacity building rather than exclusion.
The potential negative economic impacts of broad immigration restrictions were also a major concern raised in the sources.
Yes, the KFF source specifically discusses arguments that large-scale deportations could have significant negative effects on the U.S. workforce and economy.
How?
Well, immigrants are crucial contributors in sectors like agriculture, construction, and healthcare. They start businesses, they consume goods and services, and they pay billions in taxes.
So removing millions of people from that system could lead to labor shortages, hurt economic growth, and reduce tax revenue.
That's the economic argument presented. The source also touches on the complex debate about immigration and housing costs, noting differing views.
Like Vice President-elect Vance's suggestion that immigration drives up costs.
Right, contrasted with economists who are more skeptical that immigration is the primary factor. It also points out that immigrants make up a large percentage of construction workers, suggesting mass deportations could potentially worsen housing shortages by impacting the labor supply needed to build homes.
Interesting connection there. And perhaps most fundamentally, the ACLU and other sources detailed significant civil liberties concerns raised by policies involving broad restrictions and potential mass enforcement.
This comes back to the concern that policies targeting large groups, especially based on national origin or religion, risk leading to things like racial profiling, illegal detentions without proper cause,
Mhm.
warrantless searches that violate Fourth Amendment rights, and violations of the principle of equal protection under the law.
The argument is that the mechanisms required to enforce something like mass deportations inevitably involve tactics that erode constitutional protections, not just for immigrants, but potentially for citizens, too.
Exactly. The ACLU memos specifically express concern about expanded immigration detention, arguing that detaining people categorically, rather than making individualized determinations about whether they pose a flight risk or danger, violates legal principles requiring due process.
Right, individualized assessment.
Yes. They also raise concerns about the increased militarization of border communities and potential abuses, including excessive force and discriminatory targeting.
It's a comprehensive picture of the impacts and arguments against policies like the travel ban, highlighting consequences for individuals, the economy, national security relationships, and fundamental rights.
And when you look at discussions about potential future policies, these very same debates and concerns reappear. It's not like this went away.
This is where the KFF and other sources really give us a look ahead. What are some of the possibilities being discussed?
One major potential area discussed is the possibility of mass detentions and deportations on an unprecedented scale. The KFF source talks about plans that could target millions of immigrants, including long-term residents,
Wow.
potentially involving the use of the military.
Millions. That's a huge number.
Yes, it would be on a scale not seen in recent history, likely leading to widespread family separations and significant negative health consequences for those targeted.
That sounds incredibly disruptive.
Immensely. Another area involves potential restrictions on humanitarian protections.
Like for asylum seekers or refugees?
Precisely. This could involve drastically cutting the annual refugee admission ceiling, potentially shutting down tools like the CBP-1 application, which asylum seekers currently use to schedule appointments at ports of entry.
Which would make it much harder to seek asylum legally.
Correct, and eliminating temporary protected status, or TPS designations for nationals of certain countries.
And what does ending temporary protected status, TPS, mean for people currently holding it?
It means hundreds of thousands of immigrants who have been allowed to live and work legally in the U.S. because conditions in their home countries are deemed unsafe due to war, natural disaster, etc., would lose that protection and become vulnerable to deportation.
Again, raising concerns about family separation, health, and economic disruption.
Absolutely. For potentially very large numbers of people who have been here legally for years, sometimes decades.
The sources also briefly touch on potential shifts in related policy areas like surveillance and libel laws.
Yes, there's discussion about potential policies that might prioritize security over civil liberties, particularly concerning government surveillance authorities like Section 702 of FISA.
Section 702, right.
Yeah, it allows the government to surveil foreign nationals located outside the U.S. for foreign intelligence purposes, but concerns exist about backdoor searches, potentially accessing communications of Americans without a warrant. The sources note potential pressure for policies leaning more towards security in this area.
And libel laws.
On libel laws, it's noted that there's no federal libel law for a president to change directly. While state laws exist, any attempts to broaden them to make it easier to sue journalists would face significant constraints under the First Amendment protecting speech and the press. So, less direct executive control there, but still part of the broader conversation about speech and accountability.
So what we see here is that the core tensions and questions raised by the travel ban about the scope of presidential power, the balance between national security claims and civil liberties, the definition of discrimination, and the real-world human and economic consequences are not just historical footnotes.
Not at all.
They are actively present in discussions about the future direction of immigration and related policies.
It's a clear line connecting the debates we just walked through to potential actions moving forward.
Right. We've gone from the stated reasons and the legal battles of the travel ban through its profound human impacts and the broader critiques of its effectiveness and cost to civil liberties. And finally, glimpsed how these themes are playing out in discussions about what could come next.
Understanding these layers, the stated policy, the complex legal arguments and how courts responded, the historical context, the actual experiences of individuals, and the potential future implications gives you a much richer, more complete picture of this issue than you get from just scanning headlines.
It absolutely does. These sources really reveal how policies that seem straightforwardly about border control or national security intersect with fundamental questions about national identity, economic well-being, and individual rights.
Think about the core tension highlighted repeatedly throughout these sources.
Mhm.
The tension between the government's inherent and, frankly, broad power to control who enters its borders,
Mm.
and principles like non-discrimination, keeping families together, considering economic impacts, and upholding civil liberties.
How should a country navigate balancing those powerful, sometimes competing concerns in a world that's constantly changing? It's a question that doesn't have easy answers, but understanding the different facets presented in these sources is absolutely essential to even begin thinking about it.